I don't know if I said this yesterday after the briefing or the hearing. I think it was the briefing when I wanted to say it. You guys are doing such a great job of following the rules, but even more than that, asking really good questions, asking them succinctly, letting other people have turns in case your question gets asked before you. I was really proud of all the different voices and the broad range of content that we got in our briefing yesterday. So, and the hearing as well. Thank you. It makes me really proud of us. And with that, we will start with House Bill 1.
May I?
Yes.
Susan Krebs sent an email that she is having trouble with her audio and she can hear us, but she can't speak. Can we send her a phone number so that she can vote on things?
I got in on my laptop, so I'm good. Thank you. I just got in. Thank you.
I was going to let you put your hand up or something. You wouldn't have been able to ask questions, of course.
No, but I couldn't hear you, but now I can hear you.
Oh, okay, good. I'm glad it worked out. Were you on with IT? Is that how you got it done?
No, I finally got in on my laptop because my network connection didn't work. Anyway, I'm in.
Okay, good. Welcome. With that, we'll start with House Bill 181, and that is withdrawn. Somebody make a motion to allow the sponsor to withdraw the bill.
Second.
All those in favor of allowing the sponsor to withdraw her bill, say aye. All those opposed, no. Please raise your hand, and I'm going to open my panel. I see no hands raised. It's unanimous. We'll move on to House Bill 21, and that is Lisa.
House Bill 21 alters the membership of the State Board for the Certification of Residential Child Care Program Professionals by reducing the number of members from 12 to 11 and removing the requirement that a member be appointed by the Subcabinet for Children, Youth, and Families. The bill also removes the requirement that the board adopt an official seal, and there are no amendments.
Delegate Kelly.
Pretty straightforward bill. The subcommittee has supported this unanimously. I will say that Delegate Krebs and Delegate Cullison had a nice conversation, and she's going to be working with them to get some advice from their AG on sort of when board members need to recuse themselves, but that does not need to be part of this legislation. I move the bill.
Second.
Any discussion on this bill? All those in favor say aye. All those opposed, please. I don't need to hear the aye, but it's nice that you said it. Opposed, I need to see hands raised. I see no hands in the panel or on the screen. This bill passes unanimously. House Bill 32, Aaron.
House Bill 32 authorizes a petition for emergency evaluation to be provided as an electronic record. The bill authorizes a peace officer to use an emergency petition in the form of an electronic record and requires an emergency facility to accept an emergency evaluee if a properly executed petition is in the form of an electronic record. The amendments that were adopted in the Public Health and Minority Health Disparities Subcommittee clarify that the emergency petition can be transmitted and received electronically.
Delegate Pena-Melnick.
Thank you. It does not change the process. It does not change the law, how it's granted. It's just another tool. I move
the amendments.
Move the bill, move the amendments.
Is there a second?
Second.
Is there any discussion on the amendments? All those in favor say aye. All those opposed, no. Please raise your hand. Seeing no hands, the amendments pass.
Move the bill.
Is there a second?
Second.
Discussion? All those in favor say aye. All those opposed, no. Please raise your hand. On the panel. I see no hands. House Bill 32 passes unanimously. House Bill 106, Lisa.
This bill alters the required composition of the board of directors of a nonprofit health service plan by requiring the board to include at least 11 members and no more than 21 voting members. requiring the two consumer members of the board to be covered by the nonprofit health service plan or its affiliates at the time of their initial election to the board, increases from 4 to 5 the number of members of the board that may be licensed healthcare professionals, hospital administrators, or employees of healthcare professionals or hospitals, and clarifies that the board must seek to include individuals with a diverse range of experience relevant to the mission of the corporation as a nonprofit health service plan. There is one amendment on page 2 of the packet that Richard sent around. And the amendment, it's a little bit different than what the subcommittee passed. It still increases from 2 to 3 the number of the consumer members on the board. But after we had subcommittee Care First realized that they wanted the 2 consumer members to be included in the voting members of the board, which is what they currently are. And that language just got changed a little bit in the original bill draft.
It's the tractor song.
Yeah.
Yeah. Sing it, please.
So now the consumer members are as they were before voting members. Is that accurate?
Yes.
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 Okay, Delegate Cullison.
Yes, this amendment does what the First Amendment was intended to do, but the language just didn't accomplish that. So this language accomplishes having, making sure that there are at least 3 consumer members and that they are voting members. So I would move this amendment.
Is there a second?
Second.
Is there any discussion on the amendment? All those in favor say aye. All those opposed, raise your hand in the panel, please. I see no hands in the panel. The amendment passes unanimously. Delegate Cullison.
This bill passed unanimously out of subcommittee. I move this bill.
Is there a second?
Second.
Is there any discussion? All those in favor say aye. All those opposed, no. Please raise your hand. Seeing no hands, this passes unanimously. And we will move on to House Bill 119. That would be Lisa.
House Bill 119 lowers the minimum non-forfeiture rate for a life insurance annuity policy from 1% to 0.15%, and there were no amendments.
This is a pretty straightforward actuarial bill based on what's happening now in terms of nationally in terms of investments. So currently the range of numbers is between 1% and 3% because of the low interest rates that have been occurring over recent times. They're asking for the reducing to 0.15, and there was no discussion and no opposition in the subcommittee. So I move the bill.
Is there a second?
Second.
Is there any discussion on this bill? All those in favor say aye. All those opposed, no. Please raise your hand. I see no hands. The bill passes unanimously, and we'll move on to House Bill 155. Lisa?
House Bill 155 is a cleanup bill from last year. We passed 2 separate bills, one requiring the licensure of audiology assistants and one requiring, another one requiring the licensure of music therapists. And both of these were under the State Board of Examiners for audiologists, hearing aid dispensers, speech language pathologists, and music therapists. The bill is clarifying what constitutes a quorum for the board, extends existing provisions regarding the examination of licensees by a healthcare provider to apply for a music therapy or audiology assistant license, clarifies that the board may allow applicants licensed in another state to practice in Maryland under certain circumstances, specifies that existing disciplinary grounds apply to audiology assistants, authorizes a licensed audiologist to delegate duties to an assistant, and requires the board to adopt regulations for the position of audiology assistant and requirements for supervision. It adds additional disciplinary grounds for licensed music therapists, and it renames the Music Therapist Rehabilitation Subcommittee.
Delegate Kelly.
you. It sounded like a long laundry list of things in this bill, but it's really just a cleanup bill. We did all the heavy lifting last session, particularly Delegate Sample Hughes on this one. So it passed unanimously out of the subcommittee. Move the bill.
Second.
Is there any discussion on this bill? All those in favor say aye. All those opposed, no. Please raise your hand. Seeing no hands raised, the bill passes unanimously, and we're on to House Bill 163. Lindsay?
This bill modifies the definition of distribution list as it applies to the denial of inspection of distribution lists under the Public Information Act to exclude a list of recipients of specified notices relating to environmental and engineering studies on private property under the state's eminent domain statute. A custodian must allow inspection of such a notice or a list of recipients of such a notice only on receipt of a written application and a statement signed under oath that the notice or list is not intended to be used for commercial solicitation. The bill further specifies that a definition of sociological information adopted under rules or regulations by an official custodian may not include above specified notices or recipient lists. And finally, the bill requires a custodian to deny inspection of only the part of a distribution list that identifies an individual's physical address, email address, or telephone number. There are amendments that begin on page 3 of your packet. These were discussed in the Government Operations Subcommittee conceptually, and I then circulated a draft of the amendments. These are also just a little bit different from what Government Operations discussed in the subcommittee, but the subcommittee did receive this version of the amendments. They require a notice to include instructions for the recipient of the note. Require the notice to include instructions for the recipient of the notice to opt out of inclusion on a list inspected under the Public Information Act, and prohibits a person who receives an opt-out election from a recipient of a notice from including that recipient on a list inspected under the Public Information Act. Because this is the change, the custodian of a list that has been redacted must inform the person inspecting the list that it has been redacted and of how many recipients have been redacted from the list. So that last piece is what's a little bit different than what was discussed in the Government Operations Subcommittee meeting on Wednesday.
Delegate Rosenberg.
Thank you, Madam Chair. As Council has described, this is legislation that authorizes with limits access to what individuals have been given an eminent domain notice from the government so that there can be assistance can be provided to them, but not for commercial purposes. This bill passed the House unanimously last year, and the amendment is the result of really a bipartisan effort, if I may use names of Delegate Zaliga and Delegate Hill, to address some concerns that arose to further protect the privacy of individuals who would receive the notice. The bill with that amendment conceptually and no objection to the minor changes that have since been made to it, passed the subcommittee unanimously.
Would you like to move the amendment?
I move the amendment.
Would someone like to second the amendment?
Second.
Is there any discussion on the amendment?
Delegate Krebs has her hand
I
up.
see. Thank you. Delegate Krebs.
Thank you. I don't have the amendment in front of me, but I guess what I'm trying to figure out, I'm not on the subcommittee, who is the intended people that this is going to help? I mean, you say it's not to be used for commercial purposes. What is it going to be used for? What's the purpose?
Okay. It's my view, and I think the subcommittee's view, but my view would be based on experience I had dealing with constituents who live in the path of the red line, that they had also, many of them had been in the path of the highway to nowhere. And so they were displaced. They were kicked out of they had to give up their homes. And so this gives an elected official, and not just an elected official, but that's what prompted, I believe, Delegate Carr to get involved here and to introduce the bill. This gives an elected official and others the ability to help somebody who is facing the awesome power of the government to say, we are taking your property. And so we think the bill as amended is an appropriate balance of the various interests.
Okay, so given the example you just gave, so who is going to be requesting what from whom in that situation? So the situation you just mentioned, what would occur? What would be the chain of events that this bill would address?
My best understanding is that a public official, a legislator or others could gain access to the addresses of the people who receive the eminent domain notice and could then offer to assist those people in dealing with the consequences of that notice.
Okay, but you said it's not supposed to be used for commercial purposes. How would that, what if an attorney, a land use attorney requested it?
Let's get in here for a minute. I'm going to interrupt. We're on the amendment now, and the amendment is really about opting out.
Okay, well, that was my next question. So when the opt out, at what point will that person, the person whose information, what point will they know they have a chance to opt out of this information being given out? How does that occur?
Obviously, before it is given out. So I would presume that the agency wouldn't do that on its own initiative, but if it received a request for the names, it would then be the obligation of the agency to inform people that they had this option.
So how would the person know? How would the landowner know that, oh, I've got to opt out of a certain thing, so my personal information is not shared with anyone? How do you even know that?
Lindsay to talk about the mechanics of this.
The way the amendment is drafted now, when they receive the notice has to include instructions on how to opt out. So that might be fill out this form and return it to us. That's left to the entity sending the notice as far as how you opt out. But it's instructions on how to opt out, and then you can do so. And it would be up to the custodian then to redact the list as necessary based on the opt-outs that they've received.
I mean, I understand the intention of this. It's just the mechanics of it that concern me. Again, at what point does the person get to opt out? When you first are filing for eminent domain, how do you even know this request is going to come in? Or do they get the request, then they send it to everybody and say, hey, do you want to opt in or out? I just don't see how that it's going to work, but
The opt-out is a part of the notice that you receive. So it is a function of when you return your opt-out. If someone manages to put in a request before you've opted out, then you're going to still be on the list. But if you respond with your opt-out right away, you'll be redacted from the list for all future requests for that list, however many that occur in the future.
But in this particular situation, when would you foresee that the opt-out is sent to this person? At what point in time?
A part of the notice that they get in the first place. So the list is a list of who received the notice. And when you receive the notice is when you got the instruction.
Hang on. Let me try to put this in different words, and you correct me if I'm misunderstanding. A notice goes out to people saying, we're looking at your property. This is from the state to build a road here. This is an eminent domain issue or some words like that, and we're alerting you. And at that point, at the very beginning of the process, would this notification be included?
Yes.
Does that answer your question, Delegate Krebs?
No, I just didn't know if it says in there exactly when it's going to happen. And then I guess as the process
There's a
goes,
notice given under this section. So that is, as I stand corrected, that is the notice that informs the individual, not just a landlord, but a homeowner, that the state expects to take the property by eminent domain at the outset.
at the very beginning of time. All right, that's on the amendment. I have another question on the bill, but I'll hold that.
Please. Are there any other questions? I see Delegate Kaiser has a hand up and Delegate Shalega. I'm going to call on Delegate Shalega first because she was part of this drafting this amendment.
Thank you. I just wanted to clarify that this is more than just an eminent, this is in the part of the code about eminent domain, but these are letters that may go to a property owner saying we need to walk across your property for surveying, for examination, you know, and the hope is that they don't eminent domain them. But so this is a list that someone would get through a PIA from MDOT that would be part of a process that may include eminent domain, but it may include surveying, it may include other things, but DOT has to inform property owners that they may be accessing their property. So I just want to be clear, it's more than just taking the property. It's also just accessing the property.
Thank you for that clarification. I'm sure that the subcommittee chairman will be aware of that. Delegate Kaiser.
This is just when my daughter visits me with some news. Anyway, I was just going to clarify for Delegate Krebs to say. Anyway, somebody pooped, so I'm sorry to report on that as well over the online. Anyway, that this is happening at the beginning. This is happening at the beginning of the process, Delegate Krebs, before anything else happens. And I'm
Okay. We'll assume you're done because we don't hear you anymore. Okay, fine. Thank you. Thank you for the clarification. Does everybody, did we move the bill?
No, the questions were on the amendment.
Still? Oh, okay, fine. We have not voted on the amendment yet then, correct? Okay, I see
Correct.
no hands up about questions at this point. So given there are no more questions, the amendment has been moved and seconded. All those in favor, please say aye. All those opposed, please put your hand up in the panel. I see no hands. The amendment passes unanimously. Delegate Rosenberg.
I move the bill as amended.
Is there a second? Thank you. Is there discussion on the bill? Delegate Krebs.
Thank you. I'm just thinking through the whole details of how this would lay out. So it's not supposed to be for commercial use. However, I'm trying to figure out what kind of use. I understand legislators. I'm thinking of lawyers. Sorry, lawyers. I call them ambulance chasers. Sorry. But so it says, I think in the testimony, it says a requester must sign an affidavit that such a notice will not be used for commercial purposes. Okay. Is there any enforcement or a penalty for that person? I mean, it says they're not supposed to, they got to sign an affidavit, but what's the enforcement mechanism for that?
There is a provision in existing law, I think it's perjury, to say you're going to do something and then say you're not going to do something like this, and then you do.
So who follows up on that? I mean, who takes them to court and get their, what penalty? Again, I look at attorneys looking for a client, and that's what I foresee this whole thing is. But anyway, so what would be the penalty? And who does the person that information was given out have to take them to court, or is it the person that gave them the information?
Well,
Who's
since
going to follow through with
it's
that?
a misdemeanor, you would have to contact the state's attorney, as is the case for any violation of a criminal law.
And then the state's attorney would then go after the person, and there's no penalty provision. It just says they're signing an affidavit. I'm just concerned. My concern.
No,
on
it's
this-
the same penalty provision as for perjury, this kind of perjury.
So you signed an affidavit saying it's not for commercial reasons, but you can use it for legal reasons. I mean, legal, like if you're an attorney, that's not commercial.
That is commercial.
Okay, so that'd be considered commercial. All right, I just want to put that on the
If you're
record.
trying to get a client, it would be commercial.
Okay.
Let me just talk a little bit about the genesis, and I don't know if Delegate Rosenberg remembers this, and I could ask Delegate Carr, but I'm just going to do it. Delegate Carr wanted to help his constituents who were not really aware of what was going on with the widening of the Beltway. Is that right, Delegate Carr? And he was not allowed to communicate with his constituents because we passed a bill a couple of years ago to make sure people had some amount of privacy about information that was going out and was being used commercially. And it got interpreted by the department that this was not allowed under our law. We're not entirely clear that's true, but instead of arguing with them, we're just fixing it so there's no argument involved.
Okay, and I'm just trying to make sure that the people's personal
Delegate Carr.
information.
Yes, that's exactly right, Madam Chair.
Okay, yeah, I am very big on personal information being personal information, and I appreciate your concern for that, Delegate Krebs.
Just want to make sure there's enough safeguards in the bill. It sounds like the amendments take care of it, but I protect people's personal, and the issue of opting in and opting out and when you do it, sometimes it's a little challenging, but thank you.
Thank you, Delegate Krebs. Is there any other discussion? I see no other hands up. All those in favor of the bill as amended, please say aye. All those opposed, please raise your hand. I see no hands raised in the panel. The bill passes this committee unanimously. We will now turn to House Bill 167. Lindsay.
This bill establishes the commission to establish a Maryland Women Veterans Memorial to provide recommendations for the funding, design, construction, and placement of an appropriate memorial dedicated to Maryland women veterans. The commission must submit a preliminary report by February 1st, 2023, and a final report by September 30th, 2023. There is an amendment on page 7 of your packet that was considered in the Government Operations Subcommittee that alters the membership of the commission.
Delegate Rosenberg.
Yes, the amendment strikes 2 legislators because this is an election year, strikes the governor's participation because that's contrary to a constitutional, I believe, provision, and then adds representatives of veteran services organizations who are women and 1 representative of the Maryland National Guard designated by the Adjutant General. This was unanimously supported, both the amendments and the bill as amended in the committee. I would move the amendments.
Is there a second?
Second.
Any discussion of the amendments? All those in favor say aye. All those opposed, no. Please raise your hand in the panel. Seeing no hands, the amendment passes unanimously.
Move the bill as amended.
Discussion? Or sorry, second?
Second.
Discussion? All those in favor say aye. All those opposed, no. Please raise your hand in the panel. Seeing no hands, the bill passes unanimously.
Madam
Yeah.
Chair, I'm sorry to interrupt, but
All right.
question, is there an opportunity to get on as co-sponsor on this bill?
You know, I forgot all about that. And I am told this year, I believe Lindsay or Lisa or Erin, if you want to correct me, that we can do a sponsor amendment. This is the time to do it because nobody actually has to sign it in person. It can just be done in one simple amendment. If this is a bill that people would like to co-sponsor, I would say raise your hand, but I think I'm going to say if you don't want to sponsor the bill, raise your hand. Because I think we're going to have very few people who don't want to sponsor the bill. Okay, I see no hands, which means everybody who is present on this Zoom. Do we need to go through the names or can you read them, Lindsay?
I'm going to assume that Richard's got a list of who all is in attendance today, and I'll get that.
Do you, Richard? Okay, I just want to make sure that we're not putting someone on who's not here to agree to that. Okay. All right, and not that I think anybody would be very upset with me anyway, but I try to do right. So you've got the list. We can go forward, right? Everybody who's present is on this bill. And you get to learn a new thing today.
Thank you, Madam Chairman.
Thank you for bringing it up. And to the person who reminded me about raising hands for no's instead of yeses, who was that? Delegate Belcastro, thank you very much for that, because that was a big deal to go back to the thing that worked last year. Delegate Rosenberg.
I would suggest Council Lindsay Rowe provided did some research and provided a summary of monuments to veterans in the state. And if I may suggest that she send that to all members of the committee, she only sent it to a certain group the other day.
That would be great if you have that list, and if you don't, get it to Richard and he'll do it. And FYI, there are a lot of monuments in the state, and none of them include women in terms of the military kinds of memorials, which is totally reasonable given that in the old days it was different. But we need to, think about moving into the days that we're in. So great. So we voted, it passed unanimously, we're done, right? Okay, we're on to House Bill 180. Lindsay.
This bill extends the termination date for the Interstate Medical Licensure Compact. It also requires the State Board of Physicians by October 1st, 2023 to report on the status of the compact, including the number of Maryland licensees who have applied for licensure through the compact, the number of Maryland licensees who've been approved for licensure through the compact, the member states participating in the compact, and recommendations on whether Maryland should continue participation in the compact and whether any statutory changes are needed to accomplish the goal of streamlining licensure for out-of-state physicians. There's an amendment on page 9 of your packet that was considered in the Health Occupation Subcommittee that extends the termination date for the compact from 2027 to 2030 to align it with the termination date for the Board of Physicians under the Maryland Program Evaluation Act.
Delegate Kelly.
Thank you, Madam Chairman, and continuing Delegate Bagnell Day here in HGO. This bill has an amendment on it that was discussed in the full committee hearing. Everybody was on board with the amendment. It makes sense to align the dates with the regular board sunset. So the committee supported the amendment unanimously and the bill unanimously. We are big supporters of the compact process, which seems to be working well. Move the amendment.
Second.
Any discussion of the amendments? All those in favor say aye. All those opposed, please raise your hand. Seeing no hands raised, the amendments pass unanimously.
The bill.
Second.
Is there discussion on the bill as amended? All those in favor say aye. All those opposed, please raise your hand. Seeing no hands raised, the bill passes unanimously. We will now move to House Bill 227. Lindsay. Oh, where's my phone? I'm sorry.
Just go. This bill establishes Juneteenth National Independence Day as a state legal holiday and state employee holiday on June 19th. The bill also repeals the requirement that the governor annually proclaim June 19th as Juneteenth National Freedom Day. There are no amendments. This bill was not considered in subcommittee because it passed last year. It passed HGO 21-3 and the House 112-24.
And since then, the federal government has established Juneteenth as a national holiday, so there is no fiscal note to this bill. This was unanimous in committee and would move favorable.
Second.
Thoughtfully muted me, which I was unaware of. Thank you, Richard. It's okay. So it was moved and seconded. All those in favor say aye. All those.
Delegate Thundergrad, I just want to make
Krebs
it.
has a question.
Krebs.
It's not a question. I am nothing against the holiday. And when I said this last year, I think we should have swapped it out for a different holiday because we just keep adding holidays and it's a cost to everyone. So I'm running against it, not because of the day, but literally just because I think we need to revisit what holidays we give, not just keep giving more holidays. So
Delegate
that's my,
Rosenberg, would you talk about the changed fiscal note for us, please?
Well, since it is a federal holiday, it is already a day that people get off. So this bill itself will not create an additional holiday.
so whenever the federal government changes their holidays, do we automatically follow all of that?
I believe council said there's a provision in the code that provides for that.
So we do, I mean, so we already follow all the, I didn't know that. That's nice. I mean, that's my objection.
So there is no fiscal note this year, Delegate Krebs, and we've been doing it for the past 2 years, apparently.
Oh, I know we've been doing it, but that's been.
Okay, so that might change your vote. Or it might not, but I thought you should have all the information since you're not in that subcommittee. Okay. Did we move and second that bill?
Yes.
And we were voting. And I'm looking for all those in favor, say aye. All those opposed, no. Please raise your hand. Delegate Krebs votes against the bill. You will be recorded voting against the bill. I would like to be a co-sponsor of this bill. Is there anybody else who would not like to be a co-sponsor of this bill? Anybody who would not like to be, raise your hand. Delegate Krebs would not like to be, and everybody else. Delegate Shalega, Delegate Riley, Delegate Morgan, Delegate Chisholm. Okay, is that all? Have I got everybody? I don't want to mess up with anybody. Okay, so 5 people do not want to be co-sponsors. Did you get all that, Lindsay?
Yes, I did. Thank you.
Excellent, thank you. All right, the bill passed and it is now got a lot of sponsors. And the last bill of this voting session, House Bill 246, Lindsay.
This bill increases from 1 to 3 years the length of time a public body must keep a copy of a specified meeting notice or written statement about the closing of a public meeting under the Maryland Open Meetings Act. To the extent practicable, a public body must post written statements about the closing of a public meeting online. If the public body does not post a written statement, meeting minutes, or specified meeting recording online, the public body must provide an electronic copy of the written statement, minutes, or recording to a requester within 2 business days of receiving the request. That's how the bill was introduced. There are amendments that begin on page 11 of your packet that were adopted in the Government Operations Subcommittee to change that 2-day time period to 5 days, and also clarifies that the time period for providing minutes to a requester is within 5 days, or if the minutes have not yet been adopted by the public body at the time of the request, within 5 days after the public body approves the minutes.
The amendment was an attempt to give public bodies more time to post minutes on the web, and was, we thought, an appropriate accommodation to their needs, and balancing that with the purpose of the act. And it was therefore, the amendment was adopted unanimously, as was the bill itself. So I guess I would first move the amendments.
Second.
Discussion? All those in, Delegate Krebs.
Sorry to be talking so much here. One of the questions, it's a good bill, but one of the questions I asked during, I guess, the committee hearing, some of our jurisdictions have moved to just doing everything virtual, and they don't do minutes anymore, but yet we're requiring a posting of it, a written minutes. And I asked that question, somebody was going to look into it. Is there still a requirement? I read the local government code last summer, and it seemed to me it still says they must have written minutes, but we're requiring a posting of them. Would it be written, or just, hey, here's the meeting, watch the meeting?
We do not require written minutes of public bodies if they have recordings and post them online, which is why the bill references either posting the recording or the minutes online.
Okay, so you could have a whole meeting and just, you could post that and that would count.
For instance, we don't have written minutes in the General Assembly. We post our recordings of our hearings and voting.
Well, we do also, we also do have written minute, we do have written recording of our actions, which is our votes. You know what I'm saying?
That's true also. If you have a recorded vote, then you also do not need to have a written minutes. But for something like a bill hearing where the committee's not voting, we record the bill hearing and post that online, and that serves as the minutes.
But if there's another action of a body, and I'm talking about a local body, not us, there's another action that they take, it's not recorded necessarily in an action item, would they have to record that in the minutes, or would that just count on the?
Give us an example, Delegate Krebs, because coming from local government, I have no idea what you're talking about.
Well, sometimes let's say they say, oh, we want to let's vote to write a letter about X. It would be recorded in the, sometimes it's recorded in the minutes. It used to be recorded in the minutes, but now it's not. You know, they've reached agreement on doing something, an action, but it's not necessarily an action on buying a truck.
Except that if you want to send a letter as a body in a county council, you would say, all those in favor say aye, all those opposed no.
Okay, that's the way it's supposed to happen. Okay, I'm just trying to figure out, thank you. We don't always operate that way. Thank you. We should.
Delegate Riley has a question.
Delegate Riley. Can't hear you, Delegate Riley. You need to unmute.
Sorry.
Okay.
Thank you, Madam Chair. Yes, as I was looking through my notes, it does look like this amendment helped out with MACO and MML. I'm assuming that is correct. They're okay with this now, with this amendment?
Are they, counsel? Are they okay?
Are they?
They weren't present.
I believe
Okay.
that this addresses MACO's concern. I believe that MML is still concerned about having any kind of time.
Yeah, so I was wondering on the days, because the MML amendment that they had suggested didn't have any kind of day frame. And then I don't have anything from MML. So they're still a little concerned possibly as well because of the day limitation.
Yes, they would have liked to have this removed completely from the bill.
Okay, all right. And then my second question, it might be on the actual bill and not the amendment. So if you want me to wait, Madam Chair, I will.
Yes, please wait.
Okay, thank you.
For asking.
I would just, if I may,
Mhm.
I would just add the amendment is an attempt to accommodate, to compromise the interests of the act with the interests of groups such as MML and MACO and so on.
Okay, thank you.
Okay, is there any further discussion on the amendment? All those in favor say aye. All those opposed, no. Please raise your hand. And I see no hands. The amendments pass unanimously. Delegate Rosenberg on the bill.
Move the bill as amended.
Is there a second?
Second.
Thank you. Questions? Delegate Riley, we'll start with you.
Thank you, Madam Chair. Normally when I look at things with the Public Information Act, when I see closed meeting, just for clarification, or closed session, is that same as executive session?
Yes, there has to be, under the law, there are procedures for closing a meeting, and
Okay, so they're
it is the
basically the
same.
same. Okay, so my, as far as, boards and things that I'm involved in, when you go into what you would call closed session or executive session, it's normally, in most cases, probably not all, but most cases, it's for personnel purposes. So my concern here is that now, do the minutes, if it's a personnel problem, I mean, that was, never needed to be recorded or notes taken to save the privacy and all of that individual, and, don't want that all out there. Because again, it might not be true. The outcome of that personnel problem may turn out to be fine, but yet all that information is out in the public, which is not fair to that individual. So in this part, in the minutes that are now required during that time frame, are we putting it like verbatim, word from word of what's going on in this special session? Are we redacting their name in that, or what's the actual details that are in these minutes now during a closed session?
There would not be public disclosure of the matter that prompted, the details of the matter that prompted, and justifiably under the law, a closed session. So no, it would not become public via the minutes.
Could you, I'm going to follow up on that, Delegate Riley.
Thank you.
Would the procedure for personnel issues change in any way under this law from what they are now? If minutes are required, they would be required. If minutes are not required, they're not required. Is that accurate? We don't change that.
We do not, correct.
Does that address your concern, Delegate Riley?
Okay, I thought we were actually extending the minutes in that particular closed session. And now that would be public to a certain extent, where to be before it was not.
Let's ask counsel just to make sure we hear it from
No,
her.
it doesn't. These are just the minutes of the open session. There is also a bill requirement that the closing statement be provided within this 5-day time period or posted online if practicable. The closing statement will include the person who made the motion to close, the second, the vote on closing the meeting, and it will list the provision of law under which the meeting is being closed. So if we're closing to discuss personnel matters, or we're closing to legal advice, or we're closing to discuss sensitive cybersecurity information. Those are valid reasons for closing a meeting for the law. So that closing statement, as far as why you're closing the meeting, would be required to be posted online or provided electronically within 5 days. But the minutes of a closed portion of the meeting are not covered under this.
Oh, great. So then basically this bill does not change that, because I've been in that
Right.
situation. So the only thing that's being public is what always was public.
The
and
same
that was the
information that you
reason
could have gotten
why.
previously if you walked into the office and asked to inspect it in person.
Great. Thank you for that clarification. Appreciate it. Thank you. Thank you, Madam Chair.
You're very welcome. Delegate Young.
Thanks. I just want to clarify something. I've heard a reference to 5 days a few times. I thought in subcommittee, we agreed on 5 business days.
That is correct. The bill as introduced was 2 business days, and as amended, it is 5. Thank you.
Any other questions? Okay, the bill, I believe, was moved and seconded before we discussed it. So all those in favor, please say aye. All those opposed, please raise your hand in the panel or on the screen. I see no hands raised. This bill passes unanimously. That ends the work before us of the day. A good week on everyone's part. I really appreciate everything everyone has done. To my subcommittees, you did a really great job. When you do a great job, this is a boring voting session, and my goal is to be very boring when we get to this stage of the process. So thank you for that. I appreciate it. And with that, I will say, see you on Tuesday. Have a great weekend, everybody. Bye-bye.
Right.